They filed papers claiming I had dementia, and my stepdaughter Vivienne stood in front of a probate judge and said with tears in her eyes that I was no longer capable of managing my own affairs, and that she was doing this out of love, and that someone needed to protect me from myself and the probate judge looked at Vivienne with the kind of sympathetic attention that well-dressed crying women receive in courtrooms, and then the probate judge looked at me, and I looked back at her, and I thought about the 22 years I had spent sitting on the other side of exactly this kind of proceeding, and I thought about all the times I had watched people cry in courtrooms and learned to measure the distance between. Performed emotion and real grief and Vivienne's tears were the performed kind, and I knew it, and I also knew something else, which was that 2 days before this hearing I had sat in the office of Dr. Patricia Osei, the most respected neurologist in our city, and Dr. Osei had administered a full cognitive assessment and had written her findings in a 6-page letter that was currently sitting in the briefcase. Of my attorney Franklin, beside me and Vivienne, did not know about that letter, and she did not know about several other things, and I want to tell you about Vivienne before I tell you what she did, because understanding who she is matters, and Vivienne was my late husband, Edward's daughter from his first marriage, and she was 44 years old, and she had grown up with a particular combination of entitlement and resentment that comes from being the child of a wealthy man who remarried, and she had tolerated me for 19 years of my marriage to Edward, with the specific tolerance of someone who is waiting for a clock to run out, and Edward died 14 months ago from a sudden cardiac event, and the clock Vivienne had been watching apparently ran out, because within 3 months of Edward's funeral she had retained an attorney and begun building the case that I was no longer competent to manage the estate. Edward and I had built together over 19 years, and I spent 22 years as a circuit court judge, and I want you to understand what that means before I tell you how this ends. Because sitting on a bench for 22 years teaches you one thing above everything else, which is that the law is not a feeling, it is a document. And documents either say what you need them to say, or they do not, and the person who prepares their documents before they need them is almost always the person who wins, and Edward and I had prepared our documents, and the person who had helped us prepare them was Franklin, who had been our estate attorney for 16 years, and Franklin was sitting beside me in that courtroom with a briefcase that contained everything Vivienne did not know existed. And the hearing proceeded with Vivienne's attorney presenting a carefully constructed portrait of a confused elderly woman who had left the stove on twice, and had missed a dental appointment, and had once called Vivienne by the wrong name at a family gathering, and I sat and listened to this portrait, the way I had listened to arguments in my courtroom for 22 years, which is with complete attention and without visible reaction. And then Franklin stood up, and he said, "Your Honor," before the court makes any determination regarding Mrs. Eleanor Marsh's cognitive capacity, I would like to submit a current neurological evaluation conducted 2 days ago by Dr. Ermey. Patricia Osei and Vivienne's attorney objected immediately, and the objection was overruled because objecting to current medical evidence in a competency hearing is not a strong legal position. And Franklin placed Dr. Osei's letter before the court, and the letter was 6 pages and specific, and it concluded with one sentence that I want to share with you, which was this: Mrs. Marsh demonstrates superior cognitive function across all assessed domains. including executive function memory language and visuospatial ability her. Performance places her in the top 15% of adults her age, and there is no clinical basis for any finding of cognitive impairment. And the courtroom was very quiet after Franklin read that sentence, and Vivienne's attorney asked for a recess, and the judge said no, and Franklin was not finished, and he placed a second document before the court, which was an irrevocable trust that Edward and I had established 4 years earlier, that placed the bulk of our estate in a structure that explicitly excluded any beneficiary who pursued guardianship proceedings against either grantor without documented medical necessity and the trust. Language was specific, and Franklin had drafted it, and it meant that by filing this guardianship petition without legitimate medical basis Vivienne had legally disqualified herself from the inheritance she had been trying to protect through the guardianship claim, and I watched Vivienne's face in that moment, and I thought about 22 years of watching people understand in real time that their case has collapsed, and Vivienne's face was a face I had seen many times in my courtroom, and the petition was dismissed with prejudice, and the trust provisions were enforced, and Franklin sent a letter to Vivienne's attorney that same afternoon, outlining the legal consequences of pursuing any further proceedings, and I drove home from the courthouse, and I made tea in my kitchen, and I sat at the table where Edward and I had made every important decision of our 19-year marriage, and I thought about the documents and about Franklin and about Dr. Osei's 6-page letter, and I thought about 22 years of learning that the law is not a feeling, it is a document, and the person who prepares their documents before they need them is almost always the person who wins, and I had prepared my documents, and I had won, and if someone is building a case against you using your age or your grief or your supposed confusion, I want you to hear this: get the evaluation, get the attorney, get the documents in order before you need them, because the law does not care what someone says about you in a courtroom, it only cares what the documents say, and my documents said top 15%, and that was enough.